right, let's dive in. Good afternoon. I am Katie Sheehan, Managing Director and Wealth Strategist here at Crestwood Advisors. And just a little intro about Crestwood. If you are new to Crestwood or just wanting to learn about Crestwood, we have been in existence for over 20 years, 23 years. And we've had steady growth, intentional growth. We have about 8 billion under management. We have 3 offices here in New England. Our headquarters are in Boston. We have an office in Providence, one in Darien, Connecticut as well. We have a satellite office in Colorado, and we have some colleagues in Savannah, Georgia, and also down in North Carolina as well. We have about 65 folks that are working for us with lots of credentials, as you can see. We have a boutique feel, but have a very deep bench of experience with a lot of high touch service for you. No cookie cutter planning. So if you would like to learn more about Crestwood and our wealth management offerings, we invite you to reach out to one of our professionals. Now, what we all came to learn about today, who to trust with your trust. The choice of fiduciary, and we're going to focus on trustee today, but fiduciary is trustee, attorney in fact, personal representative. But like I said, we're going to focus on trustee is such an important decision when we're crafting an estate plan. But very often folks are swayed by outside influence, right? Who they think should be named as trustee. Kids can be in their ears saying, you should pick me. And they don't give the decision the respect really, or the consideration that it deserves. And we're gonna really do a deep dive on why they should give this decision the respect and consideration it deserves. So we're gonna cover the duties and liabilities and talk a little bit about is duty dead, who to pick as your trustee, who not to pick as your trustee, the merits of a corporate or professional trustee, when a hybrid approach might be warranted, the benefits of a trust protector, the importance of having robust trustee provisions in trust documents, and then we'll talk about some case studies. And we have a lot to cover. If we have time at the end, I would love to take questions. If we go right up to the hour, we have a QR code at the end. And of course, clients know how to get me and our professionals here. So please reach out with questions if we don't have time to take any at the end. So the first several slides talk about trustee duties, and there are many slides. And so that really, I hope, will drive home the importance of this role and how much consideration needs to be given to who we choose to serve in that role. So much goes into this. And that is also why a lot of folks are hesitant to serve in this capacity, right? Because there is so much that goes into it, and there is a tremendous amount of liability that follows along with that duty as well, right? And so it is critically important when we are choosing a trustee for us to know what goes along with this role. And it is also critically important for trustees to understand what they are getting themselves into, right? Because a failure to carry out their duties can result in personal or professional liability, right? And so we want to make sure that we're giving this all the thought that needs to be given. So let's dive right in. All right, so the first, right, administration of the trust. So duty to beneficiaries to administer the trust. Once you accept this position as a trustee, you're accepting the responsibility for administering the trust as a prudent person would, exercising care, skill, and caution. And that's the prudent person If that's a lay person, it's the care, skill, and caution that a lay person would exercise. If you have named a attorney, right, that's the care, skill, and caution that an attorney would exercise. So it does differ based on who you are appointing. Duty of loyalty. Duty to the beneficiaries to administer the trust solely in the interest of the beneficiaries and to carry out the grantor's purpose in creating the trust, right? The fundamental principle of a trustee is that they have been entrusted with someone else's property, right? The grantor's property, and they're accountable for that. They cannot act in a manner that's going to benefit the trustee to the detriment of the beneficiaries, unless it's been authorized by the trust document, right? Which would be probably rare. Delegation. So a trustee may, and often does, right, delegate investment and management functions if it is prudent to do so. And again, it often is. And if the language of the trust allows for same. And if they do delegate that work, right, they must exercise reasonable care, skill, and caution in selecting an agent and determining the scope of that delegation. And then, of course, periodically reviewing that agent's performance, right? So an example of that, a trustee is typically not going to be an investment professional, right? So they're going to hire an investment professional to manage the assets of the trust. But it's their job to make sure that that investment professional knows what they are doing and is carrying out that job in a way that meets the obligations of the trust and the needs of the beneficiaries. Accounting. Duty to render clear and accurate accounts for the assets. This is up for discussion lately because, and we'll talk about this in a little bit, but we have this sort of silent trust idea now, and there's also this, you could draft around certain things now because of the Uniform Trust Code, and which has been adopted in a number of states. And so there is the ability to draft around the requirement for accounting. And so you can say, okay, there is no duty to account. Is that a good idea? I don't think so, right? But if you haven't drafted around that, there is a duty to render clear and accurate accounts for the assets that are in the trust and what's going on with that assets, right? So if it's investment management accounts, right, providing statements to the beneficiaries is a way of accounting to those beneficiaries. Reporting, a little bit different from accounting, right? That is keeping the beneficiaries reasonably informed about the administration of the trust, right? What is going on with the trust, providing beneficiaries with a copy of the trust. If they have asked for it, you can also draft around that. Again, I don't know if that's wise to do, but you can draft around it in certain jurisdictions. Trustees have certain obligations to identify themselves when they have come on in a role, when a trust has gone from revocable to irrevocable, and for other things that are happening as well. And that goes a long way, right? So when we're providing the beneficiaries with an accounting and with reporting of what the trustees are doing, and you're keeping the beneficiaries informed, that's a way to keep beneficiaries happy, right? And usually to prevent them from complaining about what the trustee is doing, and hopefully to prevent some kind of complaint, right? Prudent investing should go without saying, right? But the trustee has a duty to care for and invest in trust property prudently. And again, that's as any prudent person would do, depending on who the person is. Is it a lay person? Is it an investment professional that's the trustee? Is it an attorney? So it depends who the person is and what standard of care they're held to, right? And looking at the circumstances, right? So managing the trust assets, looking at general conditions, the effects of inflation or deflation, tax consequences, the income and appreciation, other resources that are available to the beneficiaries, and I'm going to talk a little bit more about that. Liquidity needs, regularity of income that needs to be pushed out to beneficiaries, preservation and appreciation of capital that might be needed for longevity of the trust itself. So trustee needs to look at the language of the trust and what it requires, right? And then needs to invest the trust in a manner that they'll be able to carry out those whatever is required with the trust language. Diversify, right? So typically, if you are prudently investing, you are diversifying those investments in some way, shape, or form, right? So unless the language in the trust says otherwise, and sometimes it will, right? So sometimes there will be language in the trust that identifies some large position that the grantor might have, and it may say, even though this is a large stock position and this is not diversified, or it may identify a totally unproductive asset, it will say it's okay to keep that, right? Aside from that, the trustee has a duty to diversify trust assets. Duty to control the assets, right? Keep control of trust assets, know what's going on with those trust assets, to properly administer those trust assets. This is more in line with tangible assets, right? So if there is obviously real property, other sort of tangibles, jewelry, cars, other things like that, right? They need to keep control of those assets and make sure that they are properly maintained, right? Preserve trust property, right? Enforce claims. So if in their capacity as trustee, they have a valid claim against another person or entity, they have to pursue that claim, right? And if they don't, right, then a beneficiary can come back and say, why didn't you enforce that claim? In that same vein, they have a duty to defend actions, right, which may result in a loss. So how this may come up is if a claim is made against the trustee, they have a duty to defend that. If it is reasonable to do so, right? So a beneficiary might make a claim against a trustee for a breach, and there may be zero merit to that claim, right? Beneficiary may just be mad about something, which happens, right? So trustee has a duty to defend that claim. Trustee is going to use trust funds to defend that claim. And so that is going to result in funds coming out of the trust, right? Which ultimately is coming out of the pocket of the beneficiary. So he has to defend that claim. Of course, if the trustee has done something he should not have, right, that's a different story. Duty to keep trust property separate, right? So trustee is not to commingle trust property with their own trust property or with non-trust property. Again, sometimes the trust will say that trust property can be commingled. That's pretty rare, but otherwise keep it separate. Make trust property productive. Typically, this goes along with the investment provisions, but duty to make trust property productive, right? And again, sometimes there will be language that says you don't have to, right? So if there is a piece of real estate that they want to keep in the trust and maybe it is not being rented, or maybe there's some other asset that is not productive and maybe it's operating at a loss, right? But it may say we would like you to keep this asset and you have no duty to make it productive. If there is, absent language like that, trustee has a duty to make the trust property productive. See, I told you there are a lot of duties, right? But we're getting to the end of the trustee duty slides. Duty to pay income to the beneficiary. So if there's language in the trust that says that there's a mandatory income payout to a beneficiary, which often trusts have, trustee has to pay that out, right, to the beneficiary. So no getting around that. They have to deal impartially with beneficiaries, right? We can't play favorites, right? Trustees have to be totally objective, right? And so we need to be very mindful of that when we are selecting trustees, right? We need to pick someone who will be and has the ability to be objective. Co-trustees, if there's more than one trustee, these co-trustees must be acting together, right? And the only way that they are not bound to be acting together is if one trustee has delegated duties of one kind or the other to the other trustee. Otherwise, they're both totally liable for certain things. Sometimes you might see a directed trust where one trustee might be delegating all trustee responsibility to another trustee. All right, so we talked about all of the duties, which are fairly exhaustive, right? And there are more than that, but that's a pretty good list. So what are the liabilities, right? If we have been found to have breached one or some of those duties, right? And so typically a beneficiary is going to file a legal action, right? And so they may file an action to compel a trustee to perform their duties, right? So, which is simply asking a court to say, hey, please, can you just make the trustee do what they were supposed to have done in the first place? Fairly simple, right? Court, can you please enjoin the trustee from committing a breach of trust, right? If you know the trustee is about to do something that they are not supposed to do, right? A beneficiary can ask the court to prevent the trustee from doing so. Compel, right, the trustee to redress the breach. So this is the one that nobody wants, right? So if it has been shown that the trustee has breached one of their duties and there is damage, right, which is typically monetary, then the trustee may need to make whole, right? And that is typically going to come out of their pocket personally, right? So that's why we need to be mindful of breaching our duty, because we don't want to be making a trust whole because we have breached our duty. The court may require an accounting, right? So this is why when we were talking about an accounting and those trusts now where you can draft around it, I think it makes good sense just to account, right? Because if you're providing an accounting to the beneficiaries, they know what you're doing and they can't come back and say, I didn't know what you were doing. I don't know what investments were what was happening with the trust, right? If you're always providing accounts to the beneficiaries, it's out in the open, right? But had accountings not been provided, right, a court can order that the trustee account for their actions, right? The court can remove the trustee, right? You're out. Or they can appoint a special trustee until they determine whether or not removal is appropriate. They can reduce or deny trustee compensation. Trustees can charge for what they do, and they often do, right? Particularly if it's a professional trustee. So if they breach their duty and they're found to have done so, typically compensation will be denied. And then attorney's fees. So if they have been found to have breached their duty, they may be liable for paying the other party's attorney's fees. So long story short, this can be a pretty expensive affair, right? If you have a trustee that has breached their trustee duties. So we want to be mindful of that, and trustees who may be serving in this capacity, you want to be mindful of that as well, right? Okay, defenses, right? What am I going to say? I gave the beneficiaries notice, right? They knew what I was going to do. Statute of limitations has run, right? So that's always a defense. I was relying on the trust instrument, right? And that happens a lot, right? And if they were reasonably relying on the language in the trust instrument, they're going to win, right? So say trustee files a complaint about an unproductive asset, right? And there's language in the trust that says this is, you can keep this unproductive trust asset. They're going to win, right? Because trust language says they can, right? Beneficiary consent or ratification. I often, and certainly when I was practicing, I would advise clients to get indemnifications for actions that they were making as trustee. So I'd have beneficiaries sign indemnifications. And that way they could say, well, the beneficiary consented to this action that I took as trustee, right? And then if they were to complain at some point, the trustee would take out that indemnification and say, you consented to this action, right? So those are our defenses. Okay, so just a quick slide on is duty debt, now that we've talked about all these duties. So conference that I went to this past year had a very interesting section on is duty dead? Trust law has been in existence for literally hundreds of years. And there's this thinking now that because we have people shopping for different trust jurisdictions, because we have states that have more favorable trust laws than others, we have some states that have more favorable tax laws for trusts than others. We have some states where you can have silent trusts, right? Where you don't have to account to beneficiaries. You don't have to report to beneficiaries, right? So the argument is, well, if you don't have to report to the beneficiaries, if you don't have to account to the beneficiaries, do you have a duty to the beneficiary, right? So it was a very interesting argument. And also, if you're sort of forum shopping and constantly changing the situs of the trust, right? Where does that duty lie, right? So this is really sort of a scholarly argument here, but just food for thought. So I threw it in there. All right, so who do we pick, right? Now that we've talked about all the scary stuff. When you need to name, right, a trustee, you have a lot of choices, right? And it's going to be based on a number of factors. So first, you're going to think about the type of trust, right? Is it revocable or irrevocable? If it's revocable, you're going to name yourself, right? Or yourself and your spouse, typically during your lifetime. If it's irrevocable, you are not going to name yourself the grantor. You could name your spouse, but I would not recommend that. You could name your friend. You could name a professional trustee, a colleague. You could have a hybrid approach. We'll talk about all of those things. It's also going to depend on the type of assets that are being administered within the trust. So do we have liquid assets, cash and securities? Do we have illiquid assets, right? Specialty assets, real estate. Do we have assets with some complexity around them, right? Do we have, closely held business interests, things like that? Do we have special circumstances of the beneficiaries? So do we have beneficiaries with special needs or medical needs or addiction issues, or are they spendthrifts, or do we have mental health concerns, right? Do we have adverse family circumstances? Do we have a blended family, which is not always necessarily an adverse family circumstance, right? I have a blended family myself. Do we have family members that don't get along, right? Do we have an unequal distribution pattern, right? Or differing dispositive language for different beneficiaries, right? So all of these things are going to play into who is most appropriate to serve as trustee. And the grantor, right, that's the creator of the trust. They want to ensure that the trustee is going to follow the direction that's set in the trust document, right? That's the trustee's job, is to carry out the grantor's purpose, right? And administer the trust assets, right? And not to be swayed by emotional ties or outside influences, right? And as we saw on those prior slides, there's a lot of duties, right? And there's a lot of administrative work, there's a lot of paperwork and record keeping. There's investment management, right? They could be managing specialty assets, real estate, portfolio of securities, right? There's communication. So they need to keep beneficiaries and other interested parties informed and up to date. And then there's discretionary duties, right? So trustee has to assist beneficiaries sometimes with lifestyle decisions. They are asked about discretionary distributions, right? So it's up to the trustee to say yes or no sometimes, right? When they're asked for distribution, right? So if a trust is simple, and I don't mean in the tax way, and that's a topic for another webinar another day, right? I mean not complicated, right? Carrying out these duties may not be as difficult, and so we may not need a trustee who is, a powerhouse trust company, right? If it is more complex, right, and again, I don't mean in the tax sense, then the duties may be more burdensome to carry out, right? And so then we might need a trust company, or we might need a hybrid trustee. We'll talk more about that, right? And so the trustee that we select, no matter the circumstances, right, has to have a unique combination of skills, right? And as we just talked about, it's going to vary. It's going to vary by trust type, right? But no matter the trust type, they need to have strong organizational skills, right? They need to have the ability to carry out business management and investment tasks. They have to have the ability to consult with outside experts when necessary, and it's pretty much always necessary, right? They need to have honesty and integrity. I think that goes without saying. They need to be fair and impartial. Objectivity is totally necessary. They need to have good communication and strong relationship building skills with others and with the beneficiaries. And sometimes they're serving as a referee, right? And they need to have the time and desire to do this job, right? They need the expertise to manage the trust. They need to understand the trust's underlying assets, right? Including a business, if there is a business involved. And a lot of times we do plan with trusts and closely held business shares. And they have to have the time and the willingness to perform these duties. And so sometimes people don't have the time or the willingness, or one or the other, or both. And so when you're thinking about who to pick as the trustee, you need to have the discussion, particularly if it is a family member or a friend, right? Do they want this job? Can they carry this job out? You need to ask them that before you name them in the document. So who is this magical trustee, right? Do they exist? It can be hard, right? To find someone that checks all the boxes. And often the selection process makes folks paralytic, right? And and so that's why they don't do their estate plan, frankly, because they can't figure out who they will pick in all of these fiduciary roles. So we have to give careful consideration. And so seeking the guidance of your advisors, right, is super important because we can help you walk through these important decisions. So your options, right, like we talked about, are going to be you in certain circumstances, your spouse in certain circumstances, a friend, colleague, adult child, professional trustee, who is typically an attorney or a CPA or a professional fiduciary, a corporate trustee, bank or trust company, or sometimes a combination of some of those options. Who are we not going to pick as a trustee? So sometimes who we do pick is based off a process of elimination, right? There are certain people or entities, right, that we just should not pick regardless of their relationship to you. And so here are some factors to consider. Age, right? Naming someone later in life, right, as a long-term trustee for a young family is planning for failure, right? They may not live throughout the entire trust term, and they could be having declining physical or mental capacities. This could create a predictable problem, right? So don't do it, right? Name someone who is younger than you. Typically makes the most sense, right? And that can be hard sometimes because we often look to our contemporaries, right, to serve in these roles, and sometimes we need to look elsewhere. Location. So a trustee that is living in another state or another country, that presents challenges for trust administration. So state laws can create additional complications because that can create unforeseen income tax consequences. So if you have a trust that you've created in a favorable tax jurisdiction, right? Like New Hampshire, but you have named a Massachusetts trustee that loves to tax everyone and everything, right? You have just exposed that New Hampshire trust to Massachusetts income taxation, right? Similarly, if you have a domestic United States trust, but you have named a foreign trustee, you have just exposed that domestic trust to foreign trust exposure, which has a whole host of reporting requirements, et cetera. So where your trustee is located is super important, right? Sometimes we may need to change situs of the trust. And that changes over time, right? Because you can change situs of the trust over time if it's appropriate, and site wherever the trustee is changes over time. So this is, something we need to keep track of. Financial stability, right? So a trustee who has difficulty with their own finances, right, may not be the best person for this role, right? Or it could be a conflict of interest for them, or could potentially jeopardize the trust asset. So clearly, if someone is struggling with their own finances, likely not the best person for the job. Family dynamics, right? You may want to pick the responsible child who's right down the street and helps with everything. And then you realize that they don't speak to their siblings, right? that's going to create a problem. You might have a good friend who knows, the family, um, but the stress of mediating between feuding beneficiaries is too much for them. And do you really want to place that burden on them? Right. So be mindful of, are you just naming one trustee and you can't think of anyone else, right? You need to have a succession plan, right? If so-and-so can't do it, who will I name next, right? Trustees with obvious capacity concerns, right? Are they too old, right? Or do they have relationship concerns, right, with other people? Are they not good with money, right? Geographically distant trustees, right? Are they in a different state? Are they in a different country? And then family trustee selections that are ignoring known conflicts. So always be mindful of who is getting along with who, right? Okay. So a lot of times, because we do not have a family member who can serve as trustee, or it's just not a good idea for a number of reasons, and we'll talk about that as well. We want to pick a corporate or professional trustee or an independent trustee, right? So what is that, right? So we know trustee has a duty to carry out the intent of the grantor and represent the beneficiaries fairly and equitably. And this can be tough on family members, right? When they have different ideas about who should benefit what, and who can get what, right? The corporate trustee, right, who is a trust company, typically a bank, financial institution, is often used in the following scenarios, right? Where there is current or anticipated discord in the family, right? So sibling issues, blended families, strained parent-child relationships. When there is any level of asset complexity, right? So if we have anything that is more than your run-of-the-mill cash, straight bonds, straight stocks, right? So anything beyond your sort of vanilla portfolio, right? You might want to have a corporate or professional trustee, right? When we have a beneficiary with special circumstances, right? They might have a special need or a medical need, and they may be receiving benefits, and we may need a trustee who really needs to be mindful of those benefits and what distributions may or may not trip up those the benefits that they are receiving. Do we have a beneficiary that is really not good with money, right? Do we have a beneficiary that has a substance abuse issue? Do we have a beneficiary that is going through a divorce or is in a horrible marriage, right? When grantor, right, feels like a corporate fiduciary rather than a friend or a family member is more objective, right, and up to the task, or feels a corporate fiduciary would relieve friends or family of the burden of serving as a trustee, right? That is often when we're talking about when a corporate trustee is more appropriate. So how do you know if you need one, right? So if any of those things I talked about resonate, right, you might need one. They can be objective, right? They can be the heavy. They can say no, most importantly. And they can do all the stuff, right, that no one wants to do. So the tax returns, the sending out the statements, all of that stuff. Nobody really wants this job. And folks often think, oh, my kids are going to fight over who gets this job. And sometimes kids do fight over who gets this job until they actually have to carry out the job, and then they don't want it anymore, right? So you also have to manage expectations, right? So beneficiaries often assume that they have control of the trust assets and they can do whatever they want with the trust assets, right? But we know, right, that trustees are bound by the terms of the trust. So if it's only a mandatory income payout, that's all the trustee, that's all the beneficiary gets, right? If principal is at the discretion of the trustee, beneficiary can't mandate a principal withdrawal. They have to ask permission from the trustee. So if we have classes of beneficiaries, right, which could be a big age range with different needs. Corporate trustees are often better at managing all of those different expectations, more so than a layperson trustee may be able to do so. Objectivity, right? A corporate trustee is objective, right? Grantor may want to name a family member, a friend. Are they going to be able to be objective? I don't know, right? Will they have difficulty saying no? Who knows, right? So corporate trustee is likely going to be more objective. Corporate trustee also, there's an element of asset protection there, right? So they are going to know the merits of asset protection. They have that skill set. And also, importantly, they add a layer of creditor protection, right? That sometimes a family member does not, right? And so, especially today, where we have a number of states where trusts are being pierced in divorce cases, if you have an interested trustee serving, if you had a corporate trustee or a professional trustee or an independent trustee serving, there would be an asset protection or creditor protection level baked in that you wouldn't have otherwise. All right. And then continuity and preservation, sort of touched on this previously, but they're oftentimes more able to look at the long range picture here, right? So oftentimes trusts are designed to be in existence for generations, right? And so the trustee, when they're making distributions, can't make a huge distribution to one beneficiary when they know that this trust is supposed to be in existence for 100 years, right? So they need to be mindful of that when they are, making the investments for this, designing the investment policy, the asset allocation, when they're making distributions, when they're having discussions with beneficiaries, all of those things. So oftentimes they're, again, looking at this more objectively and more holistically than a layperson trustee, and certainly a family member or a friend who is looking at this with a more subjective lens. When might a hybrid approach be warranted? So that's when we're looking at having a professional trustee and a family member serve together, right? So in today's environment, we have a lot of litigious beneficiaries who sometimes have merit to their claims, but often don't, right? They're just mad. We have trust assets that have a great deal of complexity. And we have fewer individuals who either want to name a family member or they don't have a trustee in mind that is readily available to serve, right? They don't have a family member that's readily available to serve. We have a greater need for creditor and divorce protection. And we have a competitive trust market, right? Folks are shopping around for the most favorable jurisdiction. And for those reasons, a corporate or third-party trustee solution often, like we just talked about, makes a lot of sense. Some folks don't like that, right? They'll say, I've had a bad experience with XYZ trust company. There's too much control. It's too impersonal. They don't know what's going on with my family. They won't be able to adequately meet my beneficiaries' needs. So sometimes the answer to that is, let's try the best of both worlds, right? Let's have corporate trustee and a family member working together as co-trustees, right? So then you have the corporate trustee, let them do all of the work, let them be totally objective, let them say no, right? And then you can have the family member who has a pulse on what's going on, right? And knows the needs of the family. Together, they're serving as co-trustees. Importantly, the corporate trustee would be responsible for decisions about discretionary distributions, right? But sometimes that is the answer, right? All right. Benefits of a trust protector, being mindful of time here. Um, what is a trust protector? So, and this is not a trustee, I want to make that very clear. And so what is one and do you need one, right? So you've probably heard of one, right? And sometimes people talk about these being the objective third party or a check and a balance for the trust administration process or superhero of trust administration, right? But what are they, right? And are they as spectacular as folks say? I think so, right? And I don't think there is a downside to including them in a trust instrument, be it revocable or irrevocable. And when I was drafting documents, I routinely included them in my documents. Their role really is to oversee trust administration and be the eyes and the ears and the voice of the grantor when they're not available. And also to provide an element of flexibility for an otherwise inflexible, irrevocable document. They're given a lot of powers, right? And we'll talk about those in the next slide where I list out a number of powers, right? Who's typically called upon to serve in this role? So you can name who the trust protector is in the document, or oftentimes you'll name someone to name a trust protector. You may name your attorney or other trusted professional to either serve in that role or name someone to serve in that role. This is not going to be a family member. This is not going to be a beneficiary. This is not going to be the grantor, right? So want to make that very clear because they are given pretty broad authority and they have a lot of administrative capabilities. So it also has to be someone who has a pretty good command on trust administration, et cetera, which is often why professionals are called upon to serve in this capacity. And as I said, they are routinely included in many trust instruments drafted today. So here is a sampling of trust protector powers that you might see in a trust instrument today. And these are, you can draft around these, right? So this, you don't have to have a trust protector. You can have 2 of these in your trust instrument. You can have all of these. You can create them, right? But just a sampling. Power to choose or remove trustees, which is often in there. Power to direct trustees with special distributions, power to review and approve accountings, direct and veto fiduciary activities, decant and merge, change trust situs, governing law, power to grant, modify, revoke, powers of appointment. So lots of things here. And again, I'm moving at a faster pace here because I want to get to my last few slides. But so there's a lot of authority here. And again, like I said, you don't have to have all of these in here, but sometimes you do want to have these because it provides flexibility for an otherwise inflexible, irrevocable trust. But you want to be mindful of what you're giving the trust protector the authority to do. Is this a fiduciary or non-fiduciary capacity? It's often non-fiduciary. Some state statutes will have it listed as fiduciary, some will have it non-fiduciary. A lot of documents will draft and say it is a non-fiduciary role. Also important to note that this is someone that is not actively serving. So a trust protector is only serving when they're called upon to serve. So you're only appointing a trust protector when and if they're needed, right? So a trustee is always serving. A trust protector is only serving when they are called upon to serve. All right. Make sure your trustee provisions are robust in your document. So you want a way in and a way out for your trustee, because we don't want to be stuck with a wayward trustee or just a trustee that isn't great for whatever reason, right? So you want to have robust appointment provisions. You want to have resignation ability in there. You want to have robust removal provisions. You want to have guardrails around those, right? So you want to have the whens and the by whoms, right? So when can we do those things? Appointment, resign, remove, and by whom can we appoint, resign, and remove, right? So usually it's the trustee that's going to resign, right? But for appointments, when, right? During the lifetime of the grantor, during the incapacity of the grantor, upon the death of the grantor, and during the lifetime of the beneficiaries. So you want to spell that out during all of those times. When can we make appointments and removals, and who can do that, right? And then whom can do those things, right? Is it the grantor? Is it the spouse? Is it the beneficiaries? Is it the current trustee? Is the resigning trustee? Is it by court appointment? It's pretty restrictive, so I wouldn't usually recommend you put that in there, but I see a lot of documents with that in there. So you want to make sure that there's a way in and there's a way out for your trustees. And you want to put guardrails around there, right? So if you are giving your beneficiaries the ability to appoint and remove trustees, which I would typically recommend, you also may want to say, yes, they can appoint and yes, they can remove, but they have to replace whoever they are removing with an independent or a professional trustee, right? So they're not naming their best friend, right, as the trustee, right? So we want to put some guardrails. All right. So now, last few slides, right? We're going to talk about some case studies, which all are things which I have experienced in practice, not here at Crestwood, but previously. So financial damage left in the wake of a malevolent fiduciary, right? So choice of a bad fiduciary, and this is whether it's trustee, executor, power of attorney, obviously can have very negative impact on an estate, on a trust, on a family, whatever it is, right? So elderly gentleman was living with his daughter, who was taking care of him, right? She was named as his attorney, in fact, in other capacities in his documents. His other children, who did not live close by, noticed a pretty significant drop in his asset level and also his well-being. And the daughter that was living with him had a pretty bad substance abuse problem, was spending all of dad's money, was very combative with her siblings when they tried to help. And dad was also pretty fearful of daughter, and so often went along to get along, right? Even to his own detriment. And this was not a good situation and was pretty costly for all parties, mostly for dad. There was litigation involved, etc. Fast forward, eventually, good children were named as fiduciaries. Dad was moved into an assisted living facility and lived happily until he passed away. But at that point, all of his assets were gone. And his home was in such disrepair that it needed a ton of work and was difficult to sell, right? Because daughter had just completely let it go when she was living there. And at that point, the family was completely fractured. So important. And, dad just had daughter in his ear saying, you need to pick me, you need to pick me, you need to pick me, right? And so he did. Clearly, she was not best suited for the position, right? So need to pick who is the right person for the job, right? Who has your best interests in mind. The laissez-faire, trustee, right? So sometimes people pick who they think is best suited for the job. And frankly, in this instance, it was someone who should have been best suited for the job. The only trouble was they were not paying attention. So client in this instance named their attorney and their longtime friend to be their trustee of their ILET and a number of other documents. There was an insurance policy in this insurance trust that had not been reviewed in a number of years. The interest rates were in decline. And so the policy was at risk for lapsing. The insured was no longer insurable and had recently been diagnosed with terminal lung cancer. So this was $1.5 million policy that they thought that they would have for estate taxes, expenses, et cetera, which was significantly now at risk. So we stepped in, right, despite wayward attorney and trustee, brought in a professional and did a review, and we were able to get some coverage for wife who was still insurable, half the coverage that they had before. If we had not stepped in, right, and asked about this policy would have lapsed. And this trustee just was like, did not seem really bothered by this at all. The family was reluctant to remove him from this document and from other documents. And until husband died, left this gentleman involved because he was a friend. He basically committed malpractice, right? So be mindful of who we are picking, right? Because that could have been real bad. And just a bad idea all around, right? So a lot of times trusts benefit multiple generations, right? Sometimes they benefit different families, right? If we have blended families. And it's not uncommon for families to want representation, right? At the trustee level. So they might want a trustee from each generation, or if it's a blended family, from each family. And sometimes that's a good idea, and sometimes it isn't. And sometimes that's a perfect example of when a hybrid approach or just having a corporate trustee is most appropriate. So grantor created a trust for his daughter and ultimately grandchildren. Grantor had 1 daughter and 4 grandchildren. Daughter, 3 children from 1 marriage, and then 1 child from 2nd marriage, right? 3 trustees. Daughter, 1 child from 1st marriage, and then child from 2nd marriage. So during lifetime, daughter's only entitled to income. Principal can't be invaded. And then when daughter dies, then it's equal shares for kids. So occasionally, daughter's only to get income. Occasionally, she asks for distributions that are greater than what she's entitled to, which really is driven by the lower generation, right? Looking for anticipatory funds, right? Which is creating arguments, right? And immediate disapproval by other trustees, right? Daughter isn't entitled to additional distributions, and that lower level is not entitled to distributions yet either, right? So we have 2 different sets of kids and different trustees who are clearly not acting objectively, right? And so even though we want representation here, in this instance, probably not appropriate, right? And sometimes that leads to litigation, right? So here, a corporate trustee would have been a much better idea. Look at that, 1 o'clock on the nose, and I had no time for questions. So sorry about that. Please reach out to me, anyone else on your team. If you are not working with us, I invite you to do so. Please scan the QR code, reach out at our info email, our phone number. And I thank you so much for joining us today. And I hope you found that informational, and look forward to chatting with you soon.